Namaste and welcome to Legal Words of Wisdom, Nyay Gyan Ganga, which we beam every Saturday at 8 p.m. on our Virat Hindustan Sangam social media channels and which is watched all over the world. We thank our viewers for their overwhelming support for this program. As you know, on Sundays we have our regular Gyan Ganga Words of Wisdom at 8 p.m. And as you know, in this Legal Words of Wisdom on Saturday, Dr. Subramanian Swamy and Dr. Venkat Iyer discuss legal issues for the common man and how to understand various legal systems or legal words and how to be vigilant or how to understand the legal system working in India. Today is our 15th episode, and we'll be today doing the part two or the second part of the issue of invasion of privacy. Where should be the line be drawn? So we will be discussing in today's episode the issue of privacy continues to dominate the news frequently. What are the ways in which the law allows people to protect their privacy? How effective are these techniques? Do we need more laws in this area? Are people attitudes to privacy affected by the culture of the societies in which they live? What about sting operations? Are they legal? What can they be used for? What is the status of the narco analysis and other truth detection tests? Can people's phones be tapped without their permission? Here are some of these issues that will be discussed in today's episode. As you know, Dr. Venkat Iyer is a barrister, mediator, and a legal academic based in the UK. Formerly, he was in India at the Indian bar from 1981 to 1990, and then he migrated to the United Kingdoms, and he has been associated with us for starting this Legal Words of Wisdom Gyan Ganga, and we thank him for his support to put this program together. And also we thank Dr. Subramanian Swamy, who, in spite of he is actually an economist, but he has mastered the art of the legal system, and as you know, he has been in the forefront on numerous legal cases, and many of his cases are reported judgments in various courts of the High Court and the Supreme Court. So our two friends, that is Dr. Swamy and Dr. Venkat Iyer, will be discussing again today's interesting episode. I thought thank my co-host Ramesh Swamy and also our technical team, which
Dr. Swamy, I think we lost Jagdish, so you can start, Dr. Swamy. You can start with your comment.
Well, thank you very much, Jagdish. I think we have had a couple of sessions which have been very rich in ideas.
For putting this interesting program together. I wish to tell our viewers that, as we had mentioned earlier, the Gyan Ganga or legal Gyan Ganga, after it is over, we will be starting the economic Gyan Ganga probably by the first week of March, and that also will go like this program or this episode is the 15th episode in Legal Words of Wisdom. We'll be having the economic Gyan Ganga from the first week of March tentatively, and Dr. Swamy, Arvind Chaturvedi, Professor Vaidyanathan, and others will be associated with that project too, economic for the common man. So with these words of wisdom, it is over to Dr. Swamy for his opening remarks on today's episode. Over to Dr. Swamy.
Well, I left off, I had briefly begun the introduction because you had got muted. Now you're back. I'm glad. So I was saying that having listened to Dr. Venkat, and I've sort of classified the material. And some places are very well covered, some places there's much less coverage, and therefore he might consider speaking on it. First of all, from what I've heard Venkat say and what I know about the subject, there are four dimensions to privacy. First is the concept of secrecy, that you have a right to your privacy entitles you to keep certain things secret. Then there is a question of being you preferring to be anonymous, or the anonymity question. Then you don't want to be disturbed in your solitude, like sadhus, sannyasis sit in the Himalayas. They don't want to be disturbed. And finally, your attitude of being reserved is something which is right to your privacy. Now, with this comes three aspects of the right to privacy. One is freedom from intrusion. I mean, anybody and everybody just can't walk up to you and start wanting a conversation. You have a right to be protected from intrusion. And second is the control of information about oneself. How much you may bring on the public domain, or how much do you allow people to interfere with your private life? So this control of the information that flows about your personal life is something which is now presently being lying for years now with the Supreme Court in the Neera Radia versus Ratan Tata case, where all kinds of very, very lurid private details were discussed between Neera Radia and Ratan Tata, and he sought the Supreme Court to ban the publication of those Neera Radia tapes. These tapes were taken because the income tax was investigating on monumental financial fraud. And so they took the precaution, because she was highly connected, to tape of every conversation of our phone. So a huge amount that were taped over about 3-4 years, and they reveal all kinds of things. I mean, a lot of political careers also would be destroyed if that was made public. So Ratan Tata went to the Supreme Court and he got a stay. The stay was subject to conditions, but there's hardly anyone who has been able to challenge this because of the power of Tata to silence his critics. And of course, there's nothing there for me to go and get it out. But this control of information about oneself is a part of privacy. And finally, freedom from surveillance. We were talking about telephone tapping, etc. These questions Jagdish also raised just now. And so this freedom from surveillance is a part of your privacy. And the question now becomes, what are the reasonable restrictions? Because there's no fundamental right in our Constitution which is not subject to some reasonable restrictions. And those reasonable restrictions are laid down in broad categories in Section 19(2) as far as freedom of speech is concerned. And in the case of freedom of religion, freedom of worship, they have mentioned morality, public health, and public order as reasonable restrictions. So therefore, we need to discuss it. Now, one thing that Venkat has not touched, which I would like him to touch. Mahatma Gandhi said that for a public person, there's no such thing as a private life. Private life is public life is private life. Now, do you agree to this formulation, that there is no such thing for a public person who's getting the confidence of the public, so the public must know everything about him? And so their question of privacy arise. This is Mahatma Gandhi's stand. It's come in the magazine Harijan, which he edited. So what do you think about public persons? Should they be compelled to disclose all private details if it is in the public interest? I mean, of course, it has to be in the public interest, not for somebody's regalement or somebody's enjoyment. But so would you please, before you conclude, go into this question: how much of the private life of a politician or a public person, whether he's a cinema star, whether he's a football player or a cricketer, whatever, how much of his public life is the right of the public, how much of his private life is the right of the public to get to know. And so, with these comments, preliminary comments, I have the pleasure of inviting Dr. Venkat to take the floor, so to speak, and please continue with your teaching of this very important subject.
Thank you, Swami. I'll try to deal with the things that you've mentioned. There's a fair amount of ground to be covered in today's episode as well. In terms of the latest talking point on privacy in India, you may have heard about an order passed by the Allahabad High Court this week, holding that the mandatory requirement for couples wanting to marry under the Special Marriage Act to give 4 weeks' notice, inviting objections from the public, is an invasion of privacy and should therefore go. This is
Yes.
just one example of how frequently privacy issues come up before the courts nowadays. Now, resuming from where I left off last week, let me start with a quick look at the various ways in which privacy can be and is protected under the existing laws. I've already spoken about breach of confidence last week, and I maintain that that is the most widely used legal cause of action to protect privacy. Another is trespass. In simple terms, what trespass involves is the unauthorized entry of a person into another person's property. Sometimes the entry itself may be authorized, but what the person does after entering may be unauthorized. Now, how is this helpful in protecting privacy? It is helpful in situations where, for example, journalists and more particularly photographers barge into people's homes or gardens with a view to interviewing or taking pictures in situations where the person they're targeting does not want to be interviewed or photographed. And don't forget that this can also extend to people's workplaces or to such other venues as hospitals, schools, temples, clubs, etc., which are essentially private in nature. Trespass is normally a civil matter, but in India it's also an offense which can be punished with imprisonment and or a fine. I accept that the law of trespass is not helpful in situations where the person who invades another's privacy does not enter his or her property. This happens frequently, for example, when photographers take pictures of celebrities using long range telephoto lenses. There was a case of this kind involving Kate Middleton, the wife of Prince William, a few years ago. She was sunbathing on a private estate in France, and a photographer shot pictures of her from almost a kilometer away, which caused the couple a lot of distress. They were able to sue the magazines in which the pictures were published because, under French law, even invasions of privacy without entering someone's land is illegal. But trespass is useful in another context too. For example, when someone enters your property legitimately but takes undue advantage while he's inside by recording private conversations or taking pictures clandestinely. Uh, Another law that can be used, albeit in limited circumstances, is the law of nuisance. There are two types, private and public, but for our purposes, it is public nuisance which is more relevant. It is an offense under the Indian Penal Code, and this offense can be invoked if a person does something which causes danger, injury, or even annoyance to people in general at or near a property. So, if you have a situation where a large number of journalists assemble in front of a politician's or a sportsman's house, aiming to get interviews with him, and this leads to a blockage of the entrance or the exit to the house, as well as congestion on the public road outside, making it difficult for people to go about their normal business, then the police could use reasonable force to clear the nuisance. The difference between this scenario and the one involving trespass is that in this case, there is no unauthorized entry into private property. Yet another law which can help in protecting against invasion of privacy relates to harassment. In the UK, the Parliament passed a statute called the Protection from Harassment Act in 1997, under which anyone who pursues a course of conduct which any reasonable person would consider to be harassment can be sued or made criminally liable. But the conduct in question must happen at least twice. A single instance will not do. The same law also covers stalking, which is another grave invasion of an individual's privacy. This consists of shadowing a person, usually with malicious intent, monitoring him online, spying on him, etc. I haven't found an equivalent law in India, so like data protection, this remedy is not available there as far as I know. It'll be good if there was such a law, but I'm generally reluctant to recommend the creation of new laws in India because even existing laws are not enforced properly. So the addition of new laws will be worse than useless. I've already told you that in certain situations, the law of defamation can be used to protect privacy. This is mainly in relation to books or articles written about a person or speeches which are made, which the person involved does not want done. But defamation only works where what is written or said is false, not if it is true. Yet another law, which is quite useful in protecting personal privacy, is copyright. Very briefly, it works when there is some photo or document with information that you want to keep private and someone threatens to publish it. You can prevent publication by asserting your copyright in certain circumstances. I plan to do a separate session on copyright, and I shall deal with this issue at greater length on that occasion. The other point I want to talk about briefly is that attitudes to privacy differ from country to country. This is because some societies place greater value on personal privacy than others. In India, for example, people are more relaxed with sharing information about each other than in, say, Western countries. If you're traveling in a train or a bus or a plane, chances are that your fellow passengers will, within seconds of meeting you, start asking you the most personal questions about yourself without feeling that they're invading your privacy. In neighboring Bhutan, newspapers have a practice of not naming any suspected offender until they are convicted. This is taken to even greater lengths in countries like the UAE, where even convicted offenders are referred to in media only by their initials. This is because those societies feel that innocent family members of suspected or convicted criminals should not suffer any shame or disrespect simply by association. A different kind of sensitivity prevails in countries like Japan, where certain bodily functions are considered so private and so worthy of protection that people go to great lengths to neutralize any sounds that come out of lavatories by playing music at an appropriate volume. Uh, and this happens whether you're talking about homes or public places. The important point here is that there cannot be any universal standards in the enforcement of personal privacy, and much depends on local cultures. That is why there is so much variation in the thresholds fixed by laws in various countries. I next want to talk about sting operations, which, as you know, are quite common in India. These operations are usually justified as a necessary tool for investigative journalism. In simple terms, they involve the use of deception or subterfuge with the aim of exposing crime or other unacceptable behavior. But sting operations need to be distinguished from entrapment, which involves provoking an otherwise law abiding person to commit a crime. I accept that the dividing line between the two can sometimes be very thin. Unfortunately, we don't have the time to go into that interesting but complex topic, so I'll stick with sting operations. In general terms, a sting operation does involve invasion of privacy. So, to that extent, it is a breach of the law. But the law excuses sting operations when they are carried out in certain circumstances on the grounds of public interest. Remember what I said about public interest? It has the effect of overriding legal prohibitions as long as certain justifiable ends are sought to be achieved. For example, the detection or investigation of crime or other wrongdoing, or the protection of public health or even public morals. At a very simple level, if it is suspected that a hospital has unhygienic surgical practices or gets major operations carried out by very junior doctors without proper supervision, then it may be justified for a journalist to masquerade as, say, a medical orderly after gaining the confidence of people within the hospital and sneak into an operation theater to record the illegal or unethical practices there. Similarly, if it is suspected that a certain politician demands bribes for the grants of licenses or other favors, or accepts kickbacks in the award of lucrative contracts, then a journalist may well be entitled to secretly record an interview with the politician pretending to be somebody he's not, say, pretending to be a arms dealer, as happened with the Tehelka exposures, which I think was codenamed Operation West End, sometime in 2001. Now, in all sting operations, there is an invasion of privacy. So, certain safeguards need to be taken to ensure that the exemption which the law grants from prosecution or from civil liability is not forfeited. What are those safeguards? First of all, the objective of the proposed sting operation must be one which is recognized by the law. As I said earlier, it could usually be for the exposure of crime or the protection of public health and so on. A sting operation carried out for other purposes, for example, to seek retribution or gain commercial advantage, will not qualify. If there's any doubt about whether the justification offered for a sting operation is acceptable or not, the question that will have to be decided will be put to the judge. Secondly, and this is related to the first issue, the person wanting to run the sting operation will have to clearly demonstrate that the public interest will be served by the operation. Thirdly, all other avenues of achieving the objective must be explored and exhausted. So, if it is possible to get information about corruption by a politician through other means, let's say through available documentation, then the sting operation will not be justified. Or if the alleged wrongdoing can be investigated by an official agency, for example, the police, then that should be tried first. Very often, corruption in the judiciary will fall in this category. The question that a journalist should ask before considering a sting operation is, should I not complain to the Chief Justice? Of course, it's possible that the Chief Justice himself may be complicit or at least indifferent to the corruption, in which case a sting operation may be justified. Fourthly, the operation will have to be carried out with proportionality. This means that you should only use the barest minimum measures of intrusion that is needed to achieve your end. If, say, you want to expose drug taking in a cricket team, and you decide to launch a sting operation, you should use the smallest quantity of drugs, if at all, to test whether the intended targets are prone to consuming drugs, not go overboard with huge quantities. Fifthly, you should avoid what is called collateral damage while doing sting operations. So, if, for example, you want to expose a child sex ring run by a certain godman, and you manage to get into the godman's home masquerading as a devotee, you should not include any images that would identify the child victims who may happen to be around when you take the pictures clandestinely. Next, those carrying out sting operations should cooperate with the law enforcement authorities after the operation is completed. This will involve, for example, sharing any evidence that is unearthed or giving testimony in court in a case that comes up later. Where the results of the sting operation are intended to be exposed in the media, the reporting should be done in sober language, not sensationalized. This rule is broken most of the time in India because, as you know, many of the TV channels, in a headlong rush to get maximum viewership, whip up a frenzy and report the results of sting operations in extremely lurid ways. This happened, for example, in the case involving a school teacher in Delhi, a lady called Uma Khurana, who had been falsely implicated in a prostitution ring by someone with a personal vendetta, but who had to suffer mob violence as a result before it was proved that the sting operation had been completely dishonest and unlawful from the start. The record of sting operations has unfortunately not been glorious in India, but it has led to the defenestration of a few high profile figures in politics and in the professions. In addition to the Telka exposures about which I spoke a few minutes ago, when the then chairman of the BJP was forced to resign and was also convicted in the corruption case that followed the exposures, there was the case of a prominent lawyer, a man called R.K. Anand, who was punished by the Bar Council for attempting to buy off a crucial prosecution witness in the infamous BMW hit and run case of 1999. And then there was the resignation of the Andhra Pradesh governor, N.D. Tiwari, who had been caught in a sting operation in a compromising position with some women in his official residence, I think in 2009. Less luridly, there was a case of three prosecution witnesses who had turned hostile in the Jessica Lal murder case, again, I think in 1999. Talking of N.D. Tiwari reminds me that another aspect of the right to privacy is to be found in the legality or otherwise of intrusive investigation techniques. Specifically, what happened with Tiwari was that a young man called Rohit Shekhar had been convinced that Tiwari was his biological father, but whom Tiwari refused to acknowledge as his son. Shekhar waged a long battle through the courts to get Tiwari to subject himself to a paternity test, which was resisted on, among other grounds, that it would be an invasion of Tiwari's privacy. Eventually, after the Supreme Court intervened and rejected Tiwari's arguments, the test was carried out and Shekhar was shown to be his son. This case indicates that privacy concerns will be overridden in well-founded cases involving intrusive medical tests. What then about narco analysis, which, as you know, is sometimes used along with other tests like polygraph and brain mapping to verify whether a criminal suspect is telling the truth? Leaving aside arguments about the reliability of such tests, in purely legal terms, the Supreme Court has held in a case decided in 2010 that no one can be compelled to undergo the test, as it would be an unacceptable violation of their privacy. And also, of course, that it would be a violation of Article 20, Clause 3 of the Constitution, which prohibits self-incrimination. But if a person consents, then these tests can be administered. This then brings us to the issue of telephone tapping, which, as you know, is quite rampant in India, and about which also there have been quite a few cases in the courts. The first thing to say is that the statute which governs official tapping is, unbelievably, the Indian Telegraph Act of 1885. Although I would venture to suggest that there is a provision in the Information Technology Act of 2000, which also can be pressed into service now that there is a convergence in communication technologies. The grounds on which an interception can be made under the 1885 Act are the occurrence of a public emergency and also in the interests of public safety. The Supreme Court, in an important case called PUCL and Union of India, decided in 1996 um, that there are certain aspects of privacy which need to be underlined, and the court laid down elaborate guidelines to regulate this power, including that any order for telephone tapping must only be passed by a senior government official, such as the Home Secretary, that the order will not be valid for more than 2 months each time, and it will be subject to a maximum of 6 months, that there should be a periodic review of the order by a high level government committee, and that any material that is obtained through telephone taps should be destroyed as soon as its purpose was served. Now, to my knowledge, no statistics are available on the number of orders that are passed for the tapping of phones. When a case filed by a politician, the late Amar Singh, came up before the Supreme Court in 2011, the court made some caustic comments about the disorderly manner in which taps were ordered, including through the use of forged warrants. Subsequently, another can of worms was opened when certain media outlets published highly revealing conversations between a political lobbyist, Neera Radia, and a large number of journalists, politicians, and others based on tapped phone calls, to which Swamy made a reference earlier on in this episode. Following the publication of those tapes in 2008, one of the people affected, Ratan Tata, to whom also Swamy made a reference, went to court to stop further publication of his conversations and for a declaration that any publication was a violation of his right to privacy. That case has not, as far as I'm aware, been decided yet, although there was a closed door hearing sometime in 2013. Another case which made the headlines for a short while, though not on telephone tapping, was brought by the lawyer and politician Ram Jethmalani around 2011, in which he asked the Supreme Court to order the government to disclose the names of those Indians who had held illegal bank accounts abroad with huge sums of money stashed away. There was very strong resistance from the government, which argued not only that disclosure of names would be a violation of bilateral agreements that it had entered into with various foreign governments, but also, curiously, that the right to privacy of some of the account holders would be violated. Perhaps Swamy can tell us more about this case, since he has spoken on this subject from time to time. Let me now turn to something that was raised in last week's discussion, namely the Indian Supreme Court's classification of the right to privacy as a fundamental right, which could be deduced from the right to life and liberty under Article 21 of the Constitution. This happened, of course, in the Puttaswamy case, which was decided in 2017 by a 9-judge bench. There were 6 separate judgments running into a total of more than 500 pages. Even a lawyer will find reading everything that the judges have said hard going. These judgments are in parts like a sermon, in parts like a paper written for an academic seminar, in parts philosophical reflections, and I would say in parts genuflections to trendy ideas whose application in practice, at least in the Indian milieu, is likely to raise serious challenges. The other problem with these judgments is that in certain key areas, they raise more questions than they answer, which is not an unusual problem with multiple judgments. A fundamental objection that can be raised about the Puttaswamy verdict is that it disregards the fact that the makers of the Indian Constitution consciously and deliberately rejected a proposal to include an explicit provision recognizing a right to privacy. But this argument, unfortunately, did not cut any ice with the 9 judges. In keeping with the growing tradition of at least 30 years, they resorted to what many would call the lazy technique of simply saying that the right to privacy could be inferred from the right to life and liberty. The right to life and liberty, incidentally, now includes all manner of rights created by the Supreme Court: the right to go abroad, the right to a livelihood, the right against solitary confinement, the right against handcuffing, the right against delayed execution, the right to shelter, the right to sleep, the right to die with dignity, the right to housing for the homeless, also right to medical aid to injured persons, and so on and so forth. The list is very long. There's nothing wrong with any of the things that I just mentioned, but is it the job of a court or the legislature to create rights in a parliamentary democracy with a written constitution? The other problem with the Puttaswamy approach is that, as the Attorney General of India and other lawyers for the respondents pointed out during the arguments, privacy had already been recognized by the common law as an important value which was protected by various causes of action, and it was therefore quite incongruous to elevate it to the position of a fundamental right, because that would unsettle the delicate balance which had been achieved by the Constitution as originally enacted. One of the lawyers actually referred to the right to privacy as conceptually unsound and hence unworthy of being treated as a separate freestanding right. But of course, all those arguments were rejected. The only small consolation about the judgment, in my view, is that the court indicated overall that whether and to what extent the right to privacy would apply in each case that would come up in the future would depend on the facts and circumstances of the case. All one can hope for is that there will be enough wisdom and enough common sense for the judges not to go overboard with all manner of approaches which have been imported from countries whose values and mores are so different from those of India. Quite clearly, one factor which is going to dominate the debate on privacy in India as elsewhere is the impact that advances in technology will dictate. We are likely to see an explosion in litigation relating to social media, e-commerce, etc. And as things stand, there is a huge lacuna in Indian law which needs to be filled, and filled urgently. That concerns, of course, data protection. As I mentioned last week, the Indian Parliament is currently considering a data protection bill, and the sooner it is passed, I think, the better. However, even more than speed, what is required is that Parliament and the government should get the law right, failing which it will be a disaster. Given both the importance and the complexity of the topic, I'm planning to devote a separate talk to data protection in the coming weeks. Just a few more stray points on privacy and I'll be done. Firstly, there needs to be realized that in India, there are some statutory protections already in place to protect privacy. Among these are the Indian Evidence Act, which protects certain classes of communication as privileged, the Indian Post Office Act, which lists the permissible grounds for the interception of articles in the post, the Right to Information Act, under which information which involves unwanted invasion of the privacy of individuals need not be disclosed. Then there is the Indian Penal Code, which provides protection for the privacy of victims of sexual offenses. You have a separate statute, the Protection of Children from Sexual Offences Act, POCSO, as I think it is called, under which child sex cases are required to be tried in camera, and so on and so forth. I also believe that there are privacy-related provisions in other laws like the Income Tax Act, the Aadhaar Act, the Juvenile Justice Act, and so on. The point I'm trying to make is that the issue of privacy has been well understood and taken care of by the Indian Parliament long before the intervention of the Supreme Court in cases like PUCL and Puttaswamy. In relation to public figures and the extent to which they are entitled to the protection of privacy, I would say that quite clearly the determining factor will have to be the public interest. In other words, what is being exposed or sought to be exposed about the activities of a public figure will have to be relatable to the public interest. In other words, you're not prying into his private life needlessly. There will be occasions when you will have to publish material relating to private life. If, for example, the politician himself has said or done things which indicate a degree of hypocrisy, as we discussed last week. So that's broadly the principle I would lay down there, although I'm happy to develop that in the discussion that we may have shortly. One final point: how is privacy enforced by the courts? There are both civil and criminal sanctions. Under civil law, you can sue anyone who violates your privacy for compensation. This happens frequently in breach of confidence cases, and the courts can also compel the wrongdoer to hand over any unlawful profits that they may have made in the process. Besides, you can get injunctions to stop further invasion if it is a continuing one, or to prevent the invading act to take place. Injunctions are extremely useful and sometimes more valuable than damages. They're particularly so in a country like India, where cases take decades to be heard on merits. Under criminal law, it is possible for those breaching provisions which protect privacy to be fined, or in exceptional cases, to be sent to prison. Before I conclude, I just want to say that I'm aware of the huge amount of interest there is in India about the changes that WhatsApp has recently announced to its policy on information sharing with Facebook. Since that issue is connected with data protection, I'll try to address it during the session that I'm planning on that subject, as I said, in the next few weeks. But I think I'll stop here for the time being. Thank you.
Very good. There's one question which you have already answered, but I think you need to answer it again because it's been raised. That since the right to privacy is not, coded as a fundamental right explicitly in the Constitution, can it not be bypassed in litigation, saying that this is there's nowhere there in the Constitution? Now, this is a question that has come from the audience.
Yeah.
I think it needs to be clarified what you said last time, that it comes out of Article 21, and that you don't need to explicitly list all the fundamental rights of something to be derived from another. I think this is one question which from the audience came. Would you be in a position to just give a short reply, because already last time you gave quite an elaborate reply. So I thought, again, it would be benefited if you could say something on that.
Yeah, certainly. Well, there is no doubt that the Constitution does not categorize the right to privacy as a fundamental right. Actually, the Constitution does not talk about the right to privacy at all. It does not lay down anything like a right to privacy. But this is something which the Supreme Court, now in some respects not entirely unlawfully, has deduced from Article 21. Now, if the Supreme Court did the deduction responsibly, then nobody would have any complaint. But if you start saying Article 21 includes all manner of rights, and I listed about 8 or 9 in the talk, then you actually devalue the importance of Article 21, because Article 21 essentially is to protect life and personal liberty. So my complaint actually is that there is a sort of irresponsible deduction of various rights from Article 21, or for that matter, any other article of the Constitution. So as long as the court is responsible, nobody should have any difficulty. And as I said in my talk, the right to privacy or the concept of privacy is protected in so many other ways that there is no lack of law, not necessarily fundamental rights, but law to protect privacy. And so my fear is that if the Supreme Court goes along that route, then over a period of time, respect for the Constitution is going to diminish.
Well, of course, the listener should be reminded there's no such thing as an absolute fundamental right. All are subject to restrictions.
Yep.
Reasonable, what is called as reasonable restrictions.
Yep.
So even the right to privacy, although it's fundamental, but you can't claim it as an absolute right, fundamental right.
No. Well, for that matter, the right to life itself is not absolute, as we saw in an earlier episode. So you have, for example, an entirely valid punishment of execution, of capital punishment under Indian law. Now that is a very good illustration of the fact that the right to life itself is not absolute. And in those circumstances, if you were to argue that the right to privacy is absolute, then you're talking nonsense, to put it quite bluntly.
Sure. Well, Jagdish.
Venkat, there is one question on the screen. So if you can look at it, is what about security of personal data in databases maintained by companies?
Yeah. That is a point which I'll squarely and at great length talk about when I deal with data protection, directly on the issue of data protection. If you want a very short answer, I'll tell you that Indian law is not sufficient at the moment to protect such data.
That's right.
So the other question, I think that's what the other question that's coming up, and I'm interpreting it is, you talked about the paparazzis, right? So can they claim right to freedom of press?
Only if they behave within the law.
Okay.
So if, for example, paparazzi invade people's property. So I gave the example of trespass. And it is not uncommon at least in countries like India, where these huge hordes of photographers and journalists sometimes simply go into people's front gardens. I've seen that happen a lot. And I'm sure Swamy would have experienced this as well from time to time. So when that happens, clearly they are breaking the law, which is not to say that they do not have the right to put questions to someone they want to question. There's no difficulty with that, as long as they abide by the law. And quite frankly, the law also does grant them a little more latitude than is given under a strict reading of the law. So it is a question ultimately of how sensibly the law is applied.
Yeah, we have seen that even in the recent past, when I wouldn't give in the latest Sushant case, where media outlets were chasing cars, running like crazy, creating so much of disturbance and actually endangering lives of other people and themselves too in the process, saying that, this is journalism. People go to law. I mean, I've been with Dr. Swamy in multiple places. People don't have a sense that he has a personal space. They just come as close to him and jab the mic in his face. It's irritating to see that, because people don't realize. I mean, at some point in time, the police can only there's only one PSO or one police guy. How can he get away with? I mean, hundreds of these guys coming to.
What about Diana's case?
Yeah, I mean, they chased her to her death.
Yeah. Well, one law which I did not mention, which also would be applicable in the situation that you just brought up, is the law of assault and battery. Because if somebody were to thrust a mic on the face of a politician or anybody else for that matter, then clearly the ordinary criminal law will apply, regardless of whether it's an invasion of privacy or not.
Yeah, there is one other question here. Can you link the privacy laws and safeguarding IPRs? They're slightly different because IPR is not an individual right. It's for a product or an idea. So in my personal technical view, I'm just saying technically there are no links, because
that's a good question. Privacy should extend to intellectual property too.
Yeah, actually, they're intimately connected, and I will explain this when I talk about copyright. Copyright
Yeah.
in particular is so useful to protect privacy. And we've had so many very interesting cases. Now, just because I didn't want to cram it into the
Yeah,
talk
yeah,
on privacy, I said I'll keep it separate, including an extremely fascinating case which was brought by Prince Charles, our next king, and he actually won. And it has to do with China. So Swamy will be particularly interested in that case. So I'll discuss that when I talk about copyright.
Okay. Thank you.
Fine. Okay, Jagdish.
I have a question to Venkat. It is more
Yeah.
to do with India. We talk about telephone tapping, and how are the tappings against the democratic norms and all that. But after the advent of numerous social media platforms, like various methods, whether it is the government or whether it is the company which provides this, when they are snooping onto the privacy of the citizen, what remedy do the citizens have against them, and especially some of these foreign service providers?
Well, the short answer is that there is a section in the Information Technology Act of 2000 which directly regulates this, but there can be procedural problems, and it is this because the second part of your question was about what if a foreign company does it. Now it depends. If the foreign company has any tangible presence in India, then the Indian government can, of course, bring them to book. But if they, for example, had their servers, all their assets outside the country, then there are serious issues. But they are not serious issues only of enforcing privacy laws. There are serious issues enforcing any law that is violated. And that's a bigger problem for which, quite frankly, no country has found a solution yet.
No, very interesting thing is we are noticing, at least from the newspapers, that the government and the service provided sometimes collude together to expose the rights of privacy of a private citizen. We are seeing
Yep.
some controversies going around. So
Yep.
what they do is they threaten the service provider, get that information, or the police use high-handed method to get into the chat boxes and have issues out of it.
Or bribe. Bribe.
Brilliant question, actually. A brilliant suggestion. Go ahead, Dr. Swamy. I have a question now. Go ahead.
No, that's it.
No, basically, I have, let's say, in a lot of homes in Chennai, maybe all over India, now they have these security cameras. We talked about surveillance last week, right?
Yeah.
To what I know, in the US, I mean, if you want that footage, you need a warrant. But police just walk into a building and say, I want that tape. I mean, how is that legally admissible, that evidence? I mean, because it's invading, because you're pointing, technically in the US, you can't point the camera to the street. You are not allowed to. On a public street, I cannot point my camera. I can only point the camera up to where my property ends. So it's kind of unique. So in India, can the police just walk in and say, I want the footage? Is that legally admissible?
Well, the first point, of course, is that the entire procedure and law relating to legality of CCTV installation and also the images that they capture will again be something that, if you had a law, fall under the Data Protection Act. So, and at the moment, India does not have that. So that's one point. The second point actually is even more worrying in India, as I see it, is the tendency of police and other law enforcement agencies to try to capture images from a CCTV camera, not for the purposes of investigating or detecting crime, but for suppressing the possibility of conviction. So again, without going to any names, I'm sure we are all familiar with many such cases where when something very controversial happens, particularly if a person who needs to be protected, then the first thing they do is, in collusion sometimes with, for example, hotels, they go and try to take the films or the hard disk out of the CCTV cameras, and then to pretend that there is no image available. And so, of course, knows more about this than I do.
Sunanda Pushkar case is that only. All the CCTVs went blank.
Even in Sushant's case, Dr. Swamy, suddenly 2 days earlier, all the security cameras went offline.
Correct.
No, but now there are cases I know in Mumbai, Venkat.
Hmm.
The police has been telling large complexes of either private shops and or housing complexes, please have cameras focusing on the streets, for it helps us to nab culprits or the thieves who are moving around in the night.
Hmm.
Is the other way around. In fact, help in policing public spaces.
Yeah.
There
Absolutely, and
are,
that is a good thing as long as it is done even-handedly. Now,
uh,
what I was talking about were the rogue elements who want to protect certain powerful people
Correct.
when the powerful people are involved in wrongdoing. So, the importance of CCTV, nobody denies. So that's why I gave you, for example, the case of this young man called Peck in the UK. Now, the fact that there was a CCTV camera in the town center actually saved his life because they could immediately see that this man was about to commit suicide. They came and stopped him. So, of course, there is a lot of good that comes out of CCTV. But again, the law has to regulate them properly. And unfortunately, at the moment, the regulation of CCTVs is not at all done properly in India. But hopefully, if they have a good data protection law, again, I have to be careful when I say this because having a good law is no use if it's not properly enforced.
One, I think we have spoke about Aadhaar before. I mean, even people, even today, you can see the comments that are coming, and most of them, a lot of them want to know about the Aadhaar, the privacy, how the companies use them, misuse them. So let's take this question. It says, if an organization is in violation of SC verdict on Aadhaar, forces someone to produce Aadhaar, I mean, how do they do? When is it admissible? I mean, so based on this question, I think the Supreme Court has restricted what Aadhaar data can be used for, but
Yeah.
I mean, I'm telling you, brazenly violated these days. Like,
I think in Puttaswamy's judgment, it is there.
right.
Yeah.
But Dr. Swamy, you go today, I mean, you go to take a cell phone, you bring your Aadhaar in your firstborn. That's basically what they ask for, literally. And they just brazenly go, we don't know what they do with the data. There is no disclosure as to what you do with the data. Right? I mean, what are they using it for? Are they storing it? None of that is disclosed to you. I mean, people they just show. If I go and walk to anybody and say, show me your Aadhaar card, they just show it. Like what, Venkat said, that the first thing they want to get on a plane and 2 minutes later, they want to know everything about you. You go ask them, hey, can I see your Aadhaar? They just blindly go, they don't ask for why, what purpose. That education is not there at the people's level, saying that, I don't need to show Aadhaar card at all. For what? So that is still lacking, and probably it's a part of the data protection laws, Venkat.
Indeed, absolutely. It's not only the law, it's not only the enforcement of law, but it's also educating people about the use of the law. And when I say educating people, I don't only mean the public, but actually the law enforcement agencies. Because I actually have a lot of sympathy for policemen in India, as I do for policemen in many other countries. By and large, they're all right, particularly given how hard work they are, how poorly paid they are. I would say a very significant majority of them are completely above board. They're not corrupt at all, decent fellows. But unfortunately, they're not equipped with the necessary knowledge. Now, if you don't equip them with the knowledge, and they're being pushed around by politicians, so what can you do in those circumstances? So education, and in particular training, is very, very important. Just to give you an example, when Britain legislated for what in India is called right to information, what we here call freedom of information, the law was passed in 2000, but it was not brought into force until 2005. Why was there a gap? Because the government was very keen to train everybody involved in the use of that law. So that involved, for example, extensive training to the judges. Now, that is the sort of thing which is completely missing in a country like India.
Yeah, the question again is that right to information sometimes proves to be antithesis to the right to privacy.
Right to suppression.
Yeah, people ask questions which they're not entitled to know.
Yeah.
But the guy who's sitting in the desk, where does he know how to draw the line?
Exactly.
For me, RTI applies predominantly only to government or public organizations, correct?
It should.
Yes, of course.
But there are exceptions.
But there has been one case I know where somebody filed a thing with the income tax that I want to know the income tax filed by by a particular person, and he was given that.
Wow.
Yeah, yeah. Again, the right
It's
to
out of
information.
ignorance. I mean, he didn't do it deliberately or because of a bribe.
That is a topic which also I thought would be helpful for people to know about. So I'm planning a session on that as well, the right to information. And that in
Yeah.
turn also is relatable to the Official Secrets Act,
Yeah.
because there is an intimate connection. If you don't have proper harmonization of those laws, then you're going
Yes.
to really sort of create a situation which is going to be problematic.
Yeah, for instance, the Income Tax Act, we have now a section called 138, where in the public interest, the income tax assessment order of an individual or group of individuals, that report is given to you officially. In the National Herald case, I got it because they had received income from the National Herald rent, and then the income tax said that you haven't paid taxes, so taxes due 430 crore rupees, and that order, fat order, contains all kinds of documents on my case. So I
I
made
think
out that is in public interest. And the
400
government,
crores.
Again, we lost
so
it.
yes,
Okay,
there is,
sorry, we lost your audio.
and the procedure has been laid down in some acts, but on RTI we need to do more.
Yeah.
Okay. That's it.
Okay. Yeah.
Friends, am I audible?
Yeah, a little bit. There is a lag between your video and audio, but you can just go ahead.
Friends, with this, we end our today's episode on the privacy laws, which was the part 2, invasion of privacy. Where should the line be drawn? And this was the concluding part of the 2-part series. So I thank Dr. Venkat Iyer and Dr. Subramanian Swamy for this lively discussion. I thank my co-host Ramesh Swamy, and I again wish to remind our viewers that we will be starting Economic Gyan Ganga or Arth
He's gone off.
No,
after
he's
this
back, Dr.
series
Swamy.
concludes, and we will be tomorrow with another interesting on our series, another interesting episode on our normal Gyan Ganga at 8 p.m. So do keep tuned in. Thank our technical team led by Ashish Shetty. Ashish, am I audible? Sorry.
No, you're
Ashish
cutting in and out like this, but go ahead. Just complete it.
Shetty, Tejas, Vishal, Swaminathan, Rakesh, and Ishwar Iyer for their support and cooperation. See you tomorrow at 8 p.m. Indian time.
One point after the question of privacy of a public person and a private person, you have not dealt with. So next time you must
Okay. Yeah.
deal with that.
Yeah.
Okay. Thank you. Dhanyavad.
All right. Thank you.